quick announcement on the Wirewheel side. We're very excited to announce that we've just launched our new universal preference and consent platform. It's now generally available. And our new platform is really addressing those critical needs, specifically around some of the new laws in the United States and globally. And we're really, looking forward to working with companies, helping really solve for some of the new requirements around the country, especially around the CPRA enforcement decision in California.
Welcome, everybody. This is a very exciting and timely panel, of course, given that CPRA goes live, in just a few days. I know we're all kind of preparing and thinking about, how do we implement all the changes. And we've got an amazing panel today that is going to walk you through some really great insights. And I'm super excited to have them here and just want to say thank you to them for participating right off the bat. With that, I'm going to let them introduce themselves. Usama, do you want to say hello?
Hi, everybody. My name is Usama Kaf. I'm a partner at the law firm of Fisher Phillips. I am the co-chair of the firm's privacy practice group, and it's my pleasure here to be joined by Brad and Alyssa. Brad?
Hi, my name is Brad Kelso. I'm the managing partner and co-founder of a privacy consultant group here on the West Coast serving the United States called Pravagio. Happy to be here.
Alyssa?
Yep, I am Alyssa Kuhn. I am an attorney with Axiom. I service multiple in-house clients. I have 16 and a half years of in-house experience, so I'm well-versed in implementation of privacy laws. Happy to be here.
All right, awesome. So let's jump in and do a quick overview of privacy laws. We're going to talk about who consumers are under these new privacy laws that impact a lot of businesses across the country. We'll talk about compliance risks and what's at stake, and we'll focus our attention to the California Consumer Privacy Act, the CCPA, and the changes up ahead. There are references to CPRA. However, starting January 1st, it's all CCPA. CPRA is just simply an amendment to the CCPA. So once it takes effect, it's all just one law called the CCPA. All right. So as consumer privacy law is sweeping the nation, and as we see more of these laws, what is it all about? All of these laws, including the CCPA, come down to these three things. These are the objectives of consumer privacy law at their core. There's obviously a lot of nuances and details, but you want to start at very high level, the 64,000 foot level, the elevator speech of what is a consumer privacy law. It's three things. First is tell consumers what you're collecting and what you're going to use their data for when you collect it. Transparency. Consumers want transparency. Legislators want businesses to be transparent with anybody that is your consumer on what data you're collecting and how you're going to use it. The second objective of all these laws, and a lot of the regulations tend to focus on this as well, is to give consumers control back over their data. And that's because of the trend among consumers that we don't have control over our data. Everyone's watching us. Everyone is collecting data about us without us knowing it. So the idea here is these consumer privacy laws give control back to the consumers by giving consumers the ability to exercise certain rights about their data, related to their data, so that they can control the manner in which their data is collected, used, disclosed, retained. The third objective of consumer privacy laws, beyond transparency and beyond giving control back to the consumer, is to impose regulations on how businesses collect, disclose, use, share, and sell, or even retain personal data, even when the consumers are not exercising control and are not exercising those rights. So everything we're going to talk about in terms of rules and requirements that kick in, they all come down to this. So in your businesses, if you need to explain this to the CEO, the C-suite, the executives, the decision makers, high level, what do we need to know? Three things: transparency, give control back to consumers, and follow rules regarding how you collect and store and use data. And this is reflected in this trend that we're going to see across the country. This is only a picture of the current legislative map from IAPP. You have 5 states in green that have passed the law that is a broad consumer privacy law, starting with California, then Utah, Connecticut, Virginia, Colorado, and a dozen or so states that have attempted to pass a law like this, but will continue to do so. On top of this, we have federal law that may get passed in the next couple of years. I don't think it will, but some may disagree. Despite bipartisan support, I don't see it passing for a number of years, and even if it does, it probably wouldn't take effect for another 18 to 24 months after that. In the meantime, businesses that do business in multiple states are going to end up with a patchwork of various state laws that you're going to have to comply with. And then, of course, on top of this, you have the international element, because a lot of this is started outside of the U.S., actually all of it. The trend in consumer privacy legislation started outside the United States. We're sort of, a little bit late to the game, so to speak. And so a business that has consumers in Europe, for example, has to follow the GDPR. And there's a number of these new laws. One of the latest ones is in Japan as well. And so that's an added layer. In terms of U.S. Consumer privacy laws, the 5 that have passed are not all immediately effective. The CCPA obviously has been effective for 3 years. It's going to get amended significantly effective January 1st. Virginia's law takes effect January 1st, and then you have Colorado, Connecticut taking effect in July, and then after that you have Utah taking effect at the end of next year. So some of the important dates we're going to talk about to look for is this look back period in the CPRA or the CCPA. Why is that important? So in mapping your data, which we're going to talk about, in understanding how to respond to consumer requests, which we're going to talk about, one of the things you'll need to know is this look back, meaning you got to know what data you've collected during this period back to January 1st, 2022. And you got to be able to identify various things about that data that we'll need to dig into. Other important things that happen in the next 16 days or 16 days from now is that the 2 important exemptions that have been in effect since the beginning are going away. That's the employee exemption, the employment-related data exemption, and the B2B exemptions. Those are expiring. The employment and applicant and independent contractor exemption, that exempted from the scope of almost all of the requirements, with the exception of 2, all of the data of or about employees, job applicants, independent contractors, and their beneficiaries and family members collected in the employment context, as well as independent contractors that provide services. The 2 requirements that have been in effect from the beginning are reasonable security measures to protect the data and the notice at collection requirement, that initial kind of transparency to tell them what you collected and what you're going to use it for. But all of the other requirements have been put on hold. Well, all of those requirements are now going to kick in January 1st, meaning all of your employees, your job applicants, your independent contractors, and the family members and dependents of your employees are going to now be consumers under the law and will have the same rights and as any other consumer, the same rights as someone that goes on your website and interacts with your website, the same rights as someone that buys your product that is a member of the public. So who are consumers in the state under the different laws? You'll see in this chart the distinction between the 5 states. In California, the definition of consumer includes employees, job applicants, anybody in the employment context. It also includes any individuals in the B2B context. And then all the other states have created this an exemption for both categories of consumers and both categories of data, the data in the employment context and data in the commercial B2B context. What is the B2B context, and to what extent do we need to worry about it? This refers to individuals that are employees of entities that you do business with. This includes the employees of a government agency that you interact with. a nonprofit that you donate to or interact with or sponsor, the employees of a vendor that you hire to provide services, the employees of a service provider, the employees of a corporate customer. All of them are going to be consumers and will have the same rights as anybody else. Now, generally speaking, most businesses do not collect a lot of data, let alone sensitive data, about employees of their customers or employees of government agencies, but you may. And I just want to throw out an example, so to put this in context, and that is if you are a business and part of your services that you're providing to your clients is to do any kind of medical screening at their facilities, at the entrances. If you're doing that, then you're collecting the medical information of their employees or their consumers, even though you don't have a direct relationship with those individuals. You're just a service provider. You're a vendor. As a vendor, you're now collecting the data of people in that space. But that's just an example of individuals in the B2B that we would need to address. So bottom line is there's a lot of changes ahead. And one of those is to understand who your consumers are. So starting January 1st, your consumers in California are going to include your employees, the dependents and beneficiaries, your job applicants, B2B entity reps, like we talked about, like the employees or representatives or managers of a customer or an entity you interact with, independent contractors that provide services as individuals in their individual capacity. If they provide services in an entity capacity, then they would fall in the B2B entity rep bucket. But as independent contractors, they are your consumers and they have rights. The second aspect of this is to understand what data is within the scope of the CCPA. So this is just a visualization of some of the categories of employee data, just taking the employee consumer category as an example, and identifying and learning what is all the information that you collect or create about employees. This goes beyond HR because HR is not the custodian of all data. For example, security access data. Anytime an employee swaps their fob to get into a secure facility, and there's a record of that badge getting swiped, right? So you know exactly who's there. Well, that's not HR data necessarily. Who manages that data? Where does it go, right? So part of this is just to help you understand how complex employee data can be, and I'm sure Brad and Alyssa are going to talk about this a little bit more.
Hey, Osama, just a quick question. So when we talk about the B2B data, go back one.
Yes.
Most companies take for granted that their CRM, at least for many of the states, has been out of scope, right? But now that CRM, especially as you reach many B2B companies, prospects, et cetera, and I think the personal data that's already in there, it's the personal data that sneaks into CRM that's particularly dangerous. So those CRMs, Salesforce and the like, are in play, at least in California for sure.
I like that you mentioned prospects because that's a big one. We're not just talking about entities that you do business with. Even a prospect, you've collected their names, their contact information, maybe other personal information about the individual that can help you close the deal. You've learned their birthday, and you start sending them cards on their birthday to try to get your foot in the door, right? All of that is at play, and that's a really good point, Brad.
Thanks.
So what's at stake in terms of now that we've kind of covered at a very high level what information and consumers are in scope? What's at stake in California under this law? First is a private right of action for individuals who can sue individually and as a class action in the event of a data breach involving certain sensitive data. Not all data, but certain data that if it is subject to a data breach, they can sue. And the key here is, and this is why plaintiffs' lawyers are going to love it, is because they don't have to prove damages. Under any other data breach claim, they have to prove actual damages. They were harmed. How were they harmed? Not just because of the fact of the breach itself, but they have to prove actual harm, actual damages. Here, they just have to prove that causation, which means that the data breach occurred as a result of your failure or an entity's failure that you're responsible for in implementing appropriate security measures. And then they can recover minimum penalties of $100 to $750 per person, or actual damages if they can prove them if they are higher. Beyond the private right of action, employees will have a right to be free of retaliation based on an exercise of their rights under the CCPA. Now, they can't sue directly under the CCPA, but they can sue for wrongful termination under the common law if they exercise a right and then very shortly thereafter you fire them, and they can claim that based on the timing alone, there's a presumption that it was retaliatory. And then you'll have to prove that no, it wasn't. We had a bunch of other good reasons that are independent of that protected activity. But the point is, now we have another potential claim to worry about as a result of the CCPA. And the last piece is enforcement, and this is the big one in the room. These are penalties of $2,500 to $7,500 per violation that can be imposed by the agency. They can take action within 5 years. So you got to keep records of compliance for at least 5 years, otherwise you might be in trouble. And they can also audit businesses, and they will audit businesses either randomly based on a list they will keep and maintain, or they will audit, based on targeted industries, targeted businesses, targeted lines, or if they get complaints. So you have someone who doesn't like you, who went on your website and is trolling you and is, believes that you're in violation. They may complain about you to the agency, and then the agency will probably initiate it. And especially if they get multiple complaints about the same company, they might initiate an audit. The penalties can be severe. So if you fail to provide the appropriate notice, for example, to 1,000 consumers, 1,000 employees, that potentially 1,000 times 2,500, it means that 1,000 people did not receive the right disclosure, and that's a potential violation per individual. 2.5 million for 1,000 people. It can balloon up pretty quickly. There's a lot at stake. So real quick, I want to go through 7 steps to compliance related to employees in California, or at least, this is really kind of holistic. So first is ensuring that you've identified all the points where you are collecting data and you're providing the right notice and the right method containing all the required elements to all of your California consumers. For employees, any new employee should be getting one at onboarding. Current employees, you should be sending them one out 1/1/23 or shortly thereafter, as soon as possible. And then all the other points of collection, you got to figure out, how and what needs to go in that notice and how it needs to be delivered. The second is the privacy policy. Your online privacy policy needs to be updated, and I would recommend a separate privacy policy for employees for a number of reasons that I wouldn't want to publish on the website, but that is available to all employees. But that's an important step. For anyone here in HR, I strongly recommend that it not be part of an employee handbook. It needs to be a separate standalone privacy policy. The third is the consumer request management process, and we'll talk a little bit more about that later in the panel. And that is related to 6 rights, 4 of which, or at least in part, already exist for consumers. But starting January, anyone who is a consumer, including employees, will have all these rights. Then 4, 5, and 6 and 7 are all kind of self-explanatory, and we can delve into them as needed and answer questions. Security measures is 4. 5 is all the new contract terms with anyone who's a vendor that touches your data or your employees' data. 6 is minimizing how much data you're collecting and retaining, and there are some standards related to that. And then finally, making sure that anyone involved in your company's compliance with the law attends training to really understand those requirements and how to implement them and how to comply with them. So with that in mind, I want to turn it back to Brad.
Thank you. Let me get my video back. There I am. So I thought I'd insert a little bit of levity here from the left coast for those of you who are in inclement weather. Here we are in Venice, and we need to develop some new muscles in order to execute against these requirements, particularly the employment requirements. And those are the areas that we're focusing on quite a bit with our clients. And I kind of want to go through, the employment data is a little bit different than consumer data. It tends to be very, very broad. And so as a result, it ends up being in a lot of different data sources. It's not uncommon for us to find data in up to 60 to 80 data stores. And that probably doesn't surprise anybody in HR here. There's just a lot of places where it hides, shared drives, personal desktops, hard drives, all the SaaS we use. No surprise there. And so, unlike consumer data, which tends to be fairly centralized, it's a little bit broader asset inventory work there. So that's a muscle we need to focus on. Also, about 50% of it's unstructured. It's not in a database. It's a form. It's a video. It's email. It's in Excel sheets. It's in Word docs. That means that in general, you need to be aware of what's in those, at least the standard ones, and we need to be aware of potentially using unstructured scanning tools to find it. Frequently, we find HR using data sharing. SaaS is a dominant way that we, software like Concur, ADP, we just have an awful lot of SaaS, both being shared and collected by service providers. Also, unlike consumer data, where maybe you're just a retailer, this stuff lives. Employment data is not transactional. It is long-term. It changes, it morphs, but even after you let an employee go, of course, you have to retain those records. So it has a very long shelf life for you. And that kind of comes back to the problem of retention and disposal as well. I would add this one thing: if we've learned nothing more from Europe, it is that unfortunately, the employment data side gets weaponized by plaintiff attorneys as well. So it's one of the big pain points. As a result, it's pretty important that we understand that it can't just that your privacy efforts cannot be initiated in a silo. Lots of people need to be involved, and we always come in at Pravagio looking at a framework that includes not only how are we going to respond to the consumer, both on the cookie side and also on collection notice, and also on how are we going to do the DSAR kind of thing, but working on the privacy management side. Security certainly plays a very important role, not just in securing the data, but making sure appropriate access is there. Third parties, putting together data processing agreements, because we are increasingly sharing data. So all these areas of your organization, if you don't have at least a small group who is sitting in and managing privacy forward, you're going to fail in meeting these new obligations, because it's really a team effort. And speaking of teams, your employees are different. They really are different. And I'm using this, this is a Forrester Technographic study from 2021. Many of you have actually listened to this, as I have on Spokes. But there are kind of 5 groups that they track, and each of them has different attitudes. So as you approach or think about how you address your employees, your approach will vary according to the attitudes of your employees. We have reckless rebels. They're very data rich. They tend not to have tools. They're pretty open about the data. But on the far right, you have a significant number of folks that are just still not even using smartphones. And the other folks in between are using various other tools. They might be using DuckDuckGo. They might be very sensitive about providing incremental information, and they're going to be critical of your organization if you over ask or overkeep or don't create the dialogue. And I think a lot of Usama's comments about maintaining a separate privacy policy are very relevant there, because you want to call it out and you want to create that dialogue. We are in a 3-point change % unemployment world. I think we all share the need to make sure our employees feel valued, and that starts with how you treat their data. And so having an understanding of what your employees do think, depending on how they skew, makes a difference. In particular, employees themselves are different. I mentioned one of the biggest threats is that privacy would be used as a weapon. We saw that with the ADA many years ago. We expect that in California, and so we're girding for that, protecting ourselves a little bit more. And as I mentioned, it speaks to the core of your relationship, which I'm sure Alyssa's going to go into greater depth. But there's great value in how we treat the data of our employees. They care about their security. They care about confidentiality. Remember, you've got data of children, and while or minors, and while Usama didn't mention it, in California, your fines if there's a breach of minor data is about 3 times what it would otherwise be. They're particularly sensitive to that. And where does that come into play? Beneficiaries. So not just the HIPAA stuff, not just the health, but the children as well. And yes, Spacely Sprockets is well connected. We have a lot of ins and outs of data. And so HR is absolutely in the security business, and they're not used to being in the security business. In California, there needs to be an annual assessment that includes the HR data. And as I suggested to you before, it hides out in places you wouldn't expect. So it's not just the security assessment, but an integration of your policy procedures, talking about data governance. So the scope of that is, of course, all employment systems, inventory of the assets, the software, the data stores, what are security protections, and as Usama mentioned, a need to have at least a fundamental data governance. Many companies we run into, truthfully, they have just the very beginnings of data governance in terms of what they do and how they secure and protect. He didn't mention it, but California also has a specific set of particularly sensitive data that needs to be protected slightly differently. But enough about, I'm a practitioner. That's what we do for a living. I think this is a great time to shift it over to someone who's been on the front lines. And Alyssa Kuhn, take it away. I think that everybody wants to hear from you. You've been living this and breathing this for 8 years, 10 years now. I don't even remember.
It's been a while. It has been a while. Yeah, thank you, Brad. Yeah, so what does this mean from a practical standpoint, right? So we know what we legally have to do, but where do you go? How do you implement this? And that's kind of what I'm gonna walk through, hopefully. So one of the things that we've talked about, and it's been brought up quite a bit, is the employee context. And so a lot of people, myself included, right, in-house, we were kind of hiding from elements of CCPA. And as other states were kind of proposing their laws and going forward, and we were hoping for exemptions, right? You didn't want the employee data to be included. It's different. It's not consumer data. You're not doing the same things with it. You're not storing it in the same places. It's got a different purpose. There's a different intention there, a different life cycle. And so I think a lot of employers, practically, we were very hopeful that California would, at least put in place something different for employees, if not, extend the exemption on employees. Unfortunately, that hasn't happened. So we are having to skew, right? And we're having to think of, okay, well, now where do we have that HR data? The same is B2B. B2B, it's very different. That data is housed and stored in different places. It's used for different purposes. And it's tricky. B2B, that exemption, it's kind of a unique one where you have to ask the right questions within your organization to really understand where do you capture PII on individuals, right? Those sales reps and those relationships, depending on if you're in financial services, right? You might have people who sell your products and you've got very sensitive information on them to pay them their commissions and whatnot. If you're doing, background checks on individuals to do joint venture relationships, those B2B relationships, right? So that information you gathered on that owner of a company that you decided to go into business with, that now is part of this bucket of requirements, right? So now that CEO that gave you his personal information so he could qualify to do business with you, that needs to be captured, and you have to be able to respond to a request by that person to delete that data or to access that data. It's really kind of tricky.
How long did you spend in just worrying about B2B data? I'm curious. You worked for a very large company, and I don't know how long that took. I think would help other people to understand, about how long that effort took.
Of course. I mean, we probably took about 6 months to figure out those types of relationships and to kind of go and figure it out. We did do data mapping, kind of at the beginning of CCPA just to have a preliminary understanding. And then we've kind of redone it over the years. So first it was probably 6 months, and then we re-looked at that every year and spent a couple of months trying to make sure that we've captured it correct. It's also training them, right? So now we knew we had those obligations. It's kind of being preemptive and proactive and saying, okay, before we capture individual information, let's categorize it. But it's a lengthy process. And for us, for the companies that I've worked for, the types of business, it spans different, industries, right? And so you have to sort of ask the right questions. And I will tell you, there's still gaps. So you have to go back and make sure, did you really look? All right, so other exemptions, GLBA, that becomes really important on the state side. If you're a financial institution, you want that GLBA exemption. That's Gramm-Leach-Bliley Act. And that means that anything that you gather is exempt if it's related to financial services product. And that's a tricky one. If it's GLBA language, we're having to focus on, okay, what have we gathered for marketing and what have we gathered for that financial product? And a complete GLBA exemption, so an entity level exemption, that's what we wanted, right? So as in-house counsel, I'm hoping that the privacy laws are going to have a GLBA entity level exemption. That means a financial services company at its whole, at that biggest level, it's exempt. Now the data level exemptions are tricky. And those exemptions mean that the financial services data is exempt, but not the marketing data or any of that adjacent data. And I will tell you, we spent a lot of time arguing over what was GLBA data and what was not GLBA data because we didn't have that entity level exemption in California. The same with HIPAA, right? So if you are a HIPAA covered entity, what is HIPAA data and what is not HIPAA data for particular individuals. And this is a very tricky nuance. And so you're hoping, once again, for those entity level exemptions. And luckily, we've seen that in other states. We've not been so lucky in California. So you really have to draw that line and say, okay, this is related to, HIPAA, related to GLBA, and this stuff might not be. And then take an educated guess as to how to treat that information. And there's no exact science. We've talked about enforcement. We're still waiting to see where enforcement's going to happen. And that's where we get into wait and see, right? So a lot of this on the practical side, you have to kind of just do your best, right? Make an educated decision. And then we're going to have to monitor guidance from the attorney generals that have authority. In California, we've got our Privacy Protection Agency, enforcement activity by the FTC and other regulatory bodies, and then legislative action. We are still kind of not hiding, right? But we're in this holding pattern to see what's going to bubble up as being really important on the enforcement side. And it's important, kind of going back to Usama and what he had mentioned, is getting the right buy-in at the right level within your organization. It's really trying to articulate the need to monitor these things and have an agile approach to privacy. If you don't have agility, you're going to be doomed because it's going to change. It's not going to be something that's static. So moving past the exemptions, we talked a little bit about this, especially in the employee context, is the data mapping, right? And this is painful. This is so painful. When, CCPA was first passed, it was like, we have to understand what we have, where we have it, like, what are those data elements? Do they fit in those weird categories that they've created? What are the sources of those data elements? What are the third parties that we share them with or who we get them from, those purposes? Can we organize this in a way that's meaningful? So if we get one of these requests, right, that we've never seen before, that we can answer them within this 45 days, right? And it gets a little tricky. This was painful. I will tell you that we spent the better part of 18 months trying to data map, and we had to put people we had to profile them, right? And this is consistent with other organizations, is creating a personal profile. So how does a person do business with you? So are they a customer? Are they a customer of a specific product? Are they an employee? Are they a beneficiary of an employee? Are they a B2B partner? And creating a profile. Okay, so this person comes in and interacts with us this way. Where does that data go? What do we get from them? Where do we go to other third parties, background check providers or, other companies to give us information? And we have to tie it to that profile, right? And we have to then identify all the sources, all the business purposes. Why are we keeping it? When are we destroying it? What's the retention period? And organizing it. This is a painful process. And this is one of those, once again, is iterative, because you might add new product lines. So you have a new profile. You might add a new system to your employment practices, right? So now you have a cloud service provider that also has access to employment data to match them with promotion opportunities or for management purposes. you have to kind of keep asking those questions and make sure that you've got people that are educated in the organization to let you know, hey, we have this new system, or we're gathering new pieces of information. Do we need to add that to our access request process? So that's I'm going to call it a mambo, because it's a dance, and you're just going to have to continue to do it, and you've got to learn the moves. Let's see. So we're going to go ahead and go to the next topic. Sorry, not cooperating. All right, so the other one is third parties. This is a new one, and this is just as tricky as anything else. Wow, we have to classify our third parties, right? Are they a service provider, or are they a third party? So are they doing something for us under contract, or are they just receiving information or providing information or gathering information? We didn't have to do that before. I mean, it was, you wanted a service provider or a third party to do something, you went and you engaged them, but you didn't have to classify them. And now we have specific contracting terms, right? So I have to limit their use, and I have to say what they're doing with it, and I have to make sure that they don't have the right to delete it or do anything else with it. So you have these contracting requirements of the use, and you have these contracting requirements of protection. So you're having to go back to all of your vendors that are already in existence, right? And that is a difficult process. I mean, I will tell you, there's no great way to do this. And I've seen clients approach this in different ways. I think my recommendation is a risk-based approach. So go back and look at those riskiest vendors, the ones that get the super secret stuff, the really dangerous information. And you've got to go and, okay, how do I classify them? What is the statutory language I have to have in that agreement, for use and for protection? What kind of due diligence do I need to do, right? Because now I'm responsible for making sure this third party isn't going to run amok and misuse that data. So I've got to build in a due diligence process, and that alone is tricky. And once again, not a great way to, there's no secret sauce, right? There's no one way to do this, but you've got to do due diligence. That means asking at a very high level basic questions. Do you have a program, right? Are you going to secure this via a program? If you use third parties under you, so a fourth party to us, do you have a contract in place? Are you limiting their use? Are you putting something in writing that says they're not going to run amok and use that information? But these are all new concepts. The notices, right? So this coordination of notices. So where before you just deployed a third party and they might have gathered information on your behalf and used it. Now you've got to say, well, are you giving them a privacy notice? Are you giving them the rights to access their data? Are you giving them that preliminary notice of how you're going to use it and that you're going to share it with us? This was tricky also. And this is really dependent on the line of business. What's that first point of contact? What are these third parties doing for you? Should it be their notice, your notice? And then the coordination rights, right? So this is coordination of the opt-outs, the deletions, the access requests. So this is working with your third parties to decide, what do we need to do? And what do you need to do? And who is going to notify who, if at all, when we get one of these requests from these individuals that now have these rights? And once again, no great way to do this. I think a risk-based approach, I think doing your best to be transparent with your third parties, setting expectations as early as you can, and then going back and making sure that you do it again, right? Contracts, they evolve. So you've got to go through and make sure that you're always updating them. And it's easy for those new relationships. This is hard for those long-standing relationships. And I will say that I've experienced a fair amount of pushback where companies they've got too many clients coming to them trying to modify agreements and processes, and they're overwhelmed. They just don't know what to do. And you just have to be persistent, and you have to document that you've done your very best, I think, is practical advice. So the communications, we've kind of gone over this multiple times. Usama talked about the requirements for the notices. I've mentioned it as well. I think it's just important from a practical perspective to make sure that you're, and Brad, that was a great slide on the uniqueness of employees, but different notices for unique audiences, right? So differentiation between your employees, your B2B, your customers, that's a really big one. I think I've seen companies try to combine the privacy notices, and it doesn't necessarily fit. It's tricky because the relationships are different. The third parties, the data sources, all of it, they don't fit in one notice. And I think if you're trying to do that, you're kind of setting yourself up to have a really lengthy notice that's unwieldy. It's not going to be something that's usable. And I will tell you, your privacy notice is going to be the first thing that is what the agencies are looking for, right? They can see that it's on your website, or they can pretend to be a customer of yours, right? They're going to obtain those notices, and that's where they're going to get you. That's going to be where they say, this isn't clear. This doesn't meet the spirit of what we were trying to get to. That just in time, we kind of spoke about that, identifying when's that first instance of gathering data. For employees, that's tricky, right? Because you've got your initial application, then your onboarding, and then ongoing, right? When you've got open enrollment, you're getting new information from them every year. So you've got to think about, how do you get that in front of them? And then communicating exemptions, I think, is another one to highlight. If you do have an exemption, make sure you're clear about that. Make sure you're prepared to articulate that. If you're not going to honor a deletion right, if you're not going to honor an access right, somehow get that in front of them so that the consumer knows that. So I think from a practical standpoint, those are the big ones. You know the requirements. I think it's take a risk-based approach, really think about where you could get hit the worst with a violation, make sure that the communications are clear as they can be, and always go back and do it again and do it again. And that's, I mean, the best advice I can give you.
Alyssa, did you guys have many requests from agents acting on behalf of a consumer while you were building this process?
So we did not. That was not something that I've seen, but also I've been in financial services, not in a tech arena. I think it's probably more common on the tech side of things. Believe it or not, our subject access requests have actually come from like financial partners, right? So financial professionals are the ones that came to us and wanted us to respond to their request, which was kind of an interesting thing. It wasn't even consumers, but it was business partners. And we had the exemption, so it was kind of an odd thing.
Okay. Well, we
Brad,
want to
I think
do.
you bring up a good point, though. I think many companies should be prepared. They're going to get those requests from like the aggregators, right?
Right.
And they need to be ready to build a process to either respond to them, or a good explanation for why they can't deal with them directly, right? And the user needs to come to them individually.
Yeah. Well, we have a couple of final thoughts. There are some things still open, and Usama, maybe you can kind of throw out some of the things that are still munging around the legal side. We've closed some issues, and we've also learned about, at least in California, the CPPA is opening up some good faith efforts.
Oh, let's start with this good faith effort, because that's, I think, what's on everybody's mind is we're 16 days away. We're not even ready. We're not even close. Are we in trouble? Do we need to move mountains and have people cancel vacations and all of that? The answer is no. There was pushback from a lot of the business groups, right, and a lot of lobbying to postpone the enforcement of this law. And in response to that, on November 3rd, the agency added language to their proposed regulations. It's still in red line, but it reflects their current opinion and their position on enforcement. And it says, when taking enforcement actions, which won't start until July, they're going to take into consideration how long after January 1st did it take you to comply, and whether you have implemented good faith efforts. What that really means is having a plan and executing on it, and not waiting around until July. So if you're started, if you haven't started, start right away. But if you started, it doesn't mean you have to finish everything in the next 16 days. It means roll out what you can as soon as possible. So for clients that are starting right now, what I've been telling them is, even though the process that Alyssa went over for data mapping, that could take a long time, and it's complicated and intense. What can you do in the meantime to at least get the low-hanging fruit? What Alyssa talked about, which is what the public is going to see, the privacy policy. Just do something there, right? So start with at least basic templates and things that can get you 90% of the way there, 80% of the way there. Correct them as you go, modify them as you go, based on to make sure they're 100% accurate, and that's the best you can do. Open issues for next year that have not yet been addressed by the regulators, and they're about to start addressing them from the agenda for their next meeting that I just looked at, is the annual cybersecurity audit requirement. So that has not been addressed by the agency at all in the first iteration of their proposed regulations. So they're going to come out with a framework for how you are supposed to conduct an annual independent, meaning external. So you can't say we're going to just have our IT people review. It's going to be independent, because the word independent, I believe, is in the statute itself. That is expected. So expect in the next 6 months or so, we'll have a clear idea of what is this annual cybersecurity audit. How soon do you need to? How often do you need to do it? How soon after they implement the rules do you need to do it? All of those questions are unanswered right now. They will be answered hopefully in the next 6 months or so. And then data minimization. We really don't have a whole lot of rules surrounding data minimization, if any, right? So maybe they'll clarify that, and then potentially some additional rules or explanation or guidance on how to do things in the employment context. Some of the rules don't necessarily make sense in the employment context, even though you're trying to, you have to pigeonhole them. I mean, take the notice of financial incentive, for example. Potentially a wellness program that is not subject to HIPAA, that is, where you're telling employees, we'll give you $50 if you, do this and that related to wellness. Is that an incentive, a financial incentive? It might be. I mean, which makes absolutely no sense, because it's not a loyalty rewards program. It's not like a customer buying from you. But I mean, the rules make no account for that. So maybe that'll get answered. Things like, how do we take these rules that sometimes literally makes no sense in the employment context, and how do we apply them?
Sharon, I think back to you. I don't know that we have enough time for questions as much as we would like to, but we appreciate being a part of the panel, and thank you for hosting us.
Yeah, absolutely. There's one last question in the chat that I'll just quickly type. Somebody asked if they could create sort of a global baseline if they're strapped for resources. And I would say, I think, yes, that's always a good start, right? And I think the regulators are certainly going to look for, like you said, good faith, right? If you put a plan forward and they see that you're trying. I would say that helps, but there's still probably going to be edge cases that you're going to need to respond to for each individual regulation that's out there, unfortunately. So just keep in mind that a one-size-fits-all solution isn't going to.
I think having a holistic roadmap that addresses the full scope of the laws in some form, so it lays out a time frame, and then executing again, that gives you a fair amount of cover. I think if you're looking for cover, it certainly gets you off the we're negligent, right? We at least started the process.
Yep, exactly. Perfect. I think that covers us today. I mean, thank you so much, Brad, Usama, Alyssa. This was great content. I know it was a lot to fly through, so thank you so much for putting it together, and thanks for all of our attendees.